The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oye, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is of the United States and this Honorable.
Good morning. Mr. Neal, you may proceed.
Thank you, Your Honor, and may it please the court. Jason Neal on behalf of appellant John Proctor. In Aparicio Soraya, this court held that an offense is not a violent felony under the Armed Career Criminal Act when there is precedent from state courts stating that the degree of force required as an element of the offense is offensive physical contact. We have such precedent from the Maryland courts for Mr. Proctor's offense of conviction, assault with intent to prevent lawful apprehension. In Claggett against State, for example, the court said that assault with intent to prevent lawful apprehension encompasses any, quote, unlawful application of force to another, however slight. Cases like Hall and Barrios, discussed at length in our briefs, explicitly say the same thing, that the actus reus of assault with intent to prevent lawful apprehension is simple common law assault. The district court erred in concluding that this offense is a violent felony. This court should reverse and remand this case for resentencing. Now, the government resists that conclusion through a series of arguments, and I don't think that the arguments are persuasive, but I note two things critically at the outset. First, the government cites 0 Maryland cases supporting its theory that the conduct required for assault with intent to prevent lawful apprehension means something other than simple common law assault. Second, the government makes some, I think, freestanding statutory interpretation arguments, but it doesn't square them with the reasoning of Hall, Claggett, and Barrios, or with the plain statements that we cite in our briefs. And it doesn't do that, I think, because it can't. So, for example, the government cites the Supreme Court's decision in Stokely, which dealt with robbery under Florida law. And the government argues by analogy here that, like robbery in Stokely, assault with intent to prevent lawful apprehension requires force sufficient to overcome a victim's resistance. Now, this court rejected that argument in Jones, and I think it was right to do so, and the reasoning of Jones applies here even more powerfully. So in Jones, this court explained that the language that the government seizes on here, force to overcome a victim's resistance, is really unique to robbery. It is the force required to commit robbery, and it's what distinguishes robbery from other theft offenses from the person, like pickpocketing or larceny. But the court noted that the offense in Jones, which was assaulting, beating, or wounding an officer while resisting arrest, didn't share the same connection to the Armed Career Criminal Act as a textual or historical matter that robbery did. It doesn't require the same sort of force. And so the reasoning from Stokely about overcoming a victim's resistance just didn't apply there, and it doesn't apply here. Second, this court noted in Jones that Stokely squared its analysis with the Johnson 1 force standard. It didn't purport to change that standard. It simply was analyzing the particular offense of robbery, and it concluded that the force required to commit robbery satisfied the Johnson 1 force standard. And third, I think here, just as a practical matter, the idea that one needs to overcome the resistance of a victim in order to commit assault with intent to prevent lawful apprehension just doesn't really make sense. Again, force sufficient to overcome a victim's resistance is what makes robbery robbery. Here, by contrast, the actus reus of this offense is assault, and that doesn't require overcoming a victim's resistance. Stokely really discussed a physical struggle for committing robbery, even if there's a weak or feeble victim. Here, you could assault a law enforcement officer here. You could assault a person who's not a law enforcement officer for assault with intent to prevent lawful apprehension. And the intent that you need to have to commit the offense is simply the intent to get away. That either you, the person who commits the assault, or another person who is trying to evade apprehension, succeed in getting away. You just need to have an assault paired with that specific intent. And so I think for all the reasons that the court rejected the Stokely argument in Jones, the court should do the exact same thing here. The government also relies on cases discussing our statute, our offense, assault with intent to prevent lawful apprehension, in the context of the Maryland handgun statute that criminalized the use of a handgun in a crime of violence. And it argues that because Maryland courts considered this offense a crime of violence for purposes of that particular statute, that's indicative of the level of force here for Armed Career Criminal Act purposes. The problem with the government's argument is that crime of violence was defined very specifically in that Maryland handgun statute. This is discussed in the Hall case that we cite and in the Sangster, Sangster, case that we cite in our briefs. A crime of violence for that statute was defined to include an assault with intent to commit another offense punishable by more than a year in prison. So the definition of crime of violence turned on the length of imprisonment for the offense, not any requirement of violent physical conduct. And so here, for assaulted with intent to prevent lawful apprehension, the Maryland court reasoned in Hall that while preventing lawful apprehension is not itself an offense punishable by more than a year in prison, it is the equivalent of resisting arrest, which is an offense punishable by more than a year in prison. And because of that equation of preventing lawful apprehension to resisting arrest, the court concluded that assault with intent to prevent lawful apprehension satisfied this particular definition. But I think there are two things to take away here. First, the definition of crime of violence in the handgun statute the government cites did not require violent physical force. It was tied to the length of the punishment. And so I think it's just an opposite here. Second, in discussing this statute in Hall, the Maryland courts equated this offense to resisting arrest. Now, this court considered Maryland resisting arrest in apparitio seriae en banc, and the court concluded that resisting arrest itself is not a violent felony. And so we are left here with two elements to our offense. First, assault, which Maryland courts have repeatedly told us is simple common law assault. It doesn't require violent physical force. And we have an intent element that Maryland courts had equated to resisting arrest, which this court has also addressed and concluded does not require violent physical force. It's not a violent felony. And so both elements here point in the same direction, that assault with intent to prevent lawful apprehension is not a violent felony under the Armed Criminal Act. Next, the government cites case law from this court discussing other intent elements, like the intent to murder. And the government argues that an intent element can categorically make an offense a violent felony under the Armed Criminal Act. I don't dispute the premise, but I think the government's comparison of this offense to those other violent intents is misplaced here. So in the United States against Battle, this court dealt with assault with intent to murder. And the court said that it is impossible to intend the death or physical injury to your victim without using or attempting to use violent physical force under the Armed Criminal Act. And that makes sense.
Tell me your thoughts on the Barrows case, the specific facts there. I mean, we got a case there in which the most innocent conduct that was criminalized was the defendant Graham pushed into a crowd and pushing against officers. And why is that not violent conduct?
I think it's an interesting question, Your Honor, whether the push by the defendant Graham into the crowd is violent physical force. I would note that the defendant there was not pushing directly against the officers. He was pushing, like, as you said, Your Honor, into a crowd. And so I think it's a little bit difficult to gauge the level of force that person was maybe applying in the context of an actual assault there. But I think the more important point about the Barrios case is that first, the court explained the meaning of the statute and it said assault is a common law offense. It includes assault or battery. And second, that under apparitio seriae, we don't need a case involving actual offensive physical contact to commit this offense to satisfy the Armed Criminal Act, to satisfy the categorical approach, or to demonstrate that there's a realistic probability that the statute encompasses the conduct.
Any difference the Barrios, the statute there has been repealed?
I don't think the fact that this statute has been repealed changes the analysis here very much, Your Honor. When the statute was in effect for Mr. Proctor, the elements of the offense were assault with intent to prevent lawful apprehension. There's no dispute about the elements of the offense. And when he was convicted, it carried a defined punishment that differentiated it from general assault. And so, no, I don't think the fact that it's been repealed really changes much, other than that I think it sort of limits the scope of other cases that we could look to for other ways in which people have violated the statute. You know, when the statute was repealed, we were sort of cut off from further examples of how the state applied it. Fortunately, we have Hall, Claggett, Barrios, other cases that we cite in our opening brief and our reply brief that make very plain that assault in the context of the statute means assault. And they discussed this offense, including the intent element, without ever suggesting that the intent element here, the intent to prevent lawful apprehension, changes the level of physical force involved.
Also, more important, it encompasses all the meanings of common law assault, correct?
Yes, Your Honor, all the meanings of common law assault. So that could be offensive physical contact, but it could be all the other myriad ways of committing assault or battery that this court has held in cases like Royal. You said you've repeatedly observed that second-degree assault under Maryland law is not a violent felony. It doesn't require violent physical force.
You know, it's interesting, this section 386 conviction here. Your client served 1 year and then was suspended. But in 1985, that offense required an 18-month sentence. So are we certain he was convicted of under that statute? At least it looks like that's what he was required minimally to serve 18 months.
That's an interesting question, Your Honor. I'm not sure about the impact of the amount of time that he served. It may be a feature of Maryland law that his sentence was suspended in that way. I do think we can be confident that the offense he was convicted of here was assault with intent to prevent lawful apprehension. Certainly, this court can assume it for its analysis. It's not in dispute by us or the government. The pre-sentence report in paragraph 25 specifically refers to assault with intent to prevent lawful apprehension as one of the three offenses set out therein as predicate offenses for armed career criminal act purposes. And so I think this court can securely consider this case with that offense in mind.
Do you see any tension in the fact that 386 talks about aggravated assault with your argument?
No, Your Honor, I don't think that the idea of this as an aggravated assault is a problem for us. The statute doesn't use the word aggravated, but I would acknowledge that cases, including Claggett, called this an aggravated assault. So it's maybe 2 points, Your Honor. So Claggett called this an aggravated assault, but Claggett also repeatedly referred to the conduct required as simple common law assault or battery. Second, we discussed cases in our reply brief about the meaning of aggravated assault. I think the government's idea here is that aggravated means violent, but that's not really the case. Aggravated just means there's the presence of some aggravating factor. That could be that the outcome of the offense is violent or that there's violent intent, but it could also mean some other prescribed intent. As here, the intent that the assault interfere with a legitimate attempt to arrest a person. I think as a policy matter, Maryland is entitled to consider that specific intent to be one worthy of pairing with assault in a criminal statute and setting out a defined punishment for it. But I don't think it's indicative of the level of physical force required to complete the offense and satisfy the statute. I would just note one other thing before I conclude, Your Honor, unless there are other questions. The government makes this no scitura associus argument that there are other pieces of the Section 386 offense that are more violent. 2 points in response to that, I would say. First, the inference that the government draws from that assault must mean something heightened, something above normal assault, is just not supported by the Maryland case law. There's no indication that that's how Maryland courts interpret this statute. And second, this court rejected a similar no scitura associus argument in Jones, where the government relied on the fact that assault was used in a series, I think assaulting, beating, or wounding an officer to mean that assault must mean some more serious thing than common law assault. And the court rejected that proposition there. And again, I think it should reject that proposition here. If the court has no further questions, I will happily reserve the remainder of my time for rebuttal.
Thank you, Mr. Neal. Counsel, you'll have to help me with your last name. I would like to pronounce people's name correctly.
Dewey.
Suey,
Your Honor.
Yes, thank you. You may proceed, Suey.
Thank you, panel, and may it please the court. I'd like to start with addressing a question that Judge Motz alluded to, and it's about the structure of the statute. The structure of the statute that existed at the time, it was clearly meant to encompass aggravated or elevated assault offenses. Here, within the same statute, we have things like assault by shooting, assault by stabbing, cutting, or wounding, assault with intent to maim, disable, or disfigure. This is some of the most egregiously violent assaultive conduct that Maryland law has criminalized. Now, admittedly, there is a difference between the completed act of maiming, let's say, which must result in physical pain or injury, but Johnson does not require that the force applied always result in physical pain or injury. It only requires that the force used is capable of causing physical pain or injury. And that was part and parcel to the Supreme Court's conclusion in Stokely. That force capable of overcoming a victim's resistance must be capable of causing physical pain or injury. This is true, the court said in Stokely, because robbery, the offense in that case, necessarily involves a physical confrontation and struggle, and that it is the physical contest between the criminal and the victim that is itself capable of causing physical pain and injury. And from that, there would be no need to distinguish assault with intent to prevent lawful apprehension from something like resisting arrest, and in so doing, also assigning more severe penalties if it just encompassed the same type of conduct that was already covered under the statute. Not only that, but we have...
Excuse me. Is de minimis assault sufficient for a conviction here?
It is insufficient for a conviction under assault with intent to prevent lawful apprehension. It is not sufficient. And
Sorry, I thought you said it was sufficient, then you said it wasn't. I guess I misunderstood.
No, I'm sorry, insufficient. It's not sufficient, Your Honor. De minimis assault is not sufficient. And we know this because, for one, we have Maryland case law and the case of Claggett, which states that 386 is directed at aggravated assaults against the person. And we also have another case, Sangster versus State, and that's from Maryland's highest court, in which the court characterizes assault, this type of assault, as an aggravated assault that clearly, and I emphasize the word clearly because the Maryland courts use that word, falls within the definition of crime of violence. Now, there is the caveat there that crime of violence, the definition of crime of violence in Maryland differs from the definition of violent felony under the ACCA, but it still demonstrates an acknowledgement by the Maryland courts that this is being recognized as an aggravated as well as a violent offense. And we also know this, as I stated before, because the structure of the statute. And under the appellant's logic, on the other hand, the portion of Section 386 that includes intent to maim, disfigure, or disable would also be rendered nonviolent. And the same logic extended even further, it would seem, would also conflict with this court's prior decision in Battle, in which it held that assault with intent to murder is a force clause crime of violence.
No, it doesn't conflict, Mr. Short. What the argument was, and of course, you can argue you heard something different, but what he was saying that that's an assault and it comes with it an objective. The objective, murder. The objective, robbery. Those things, you do have to do the assault to the level to accomplish the objective, but it clears out. But here it doesn't. Maryland has said that this encompasses common law assault. Now, you're saying that you have to, the only way you can assault in terms with the objective of avoiding apprehension is violence. Is that what your position is? Because that's what you'd have to do. That's what he's doing. He said the only way you can do murder and those kind of things, you have to elevate there. Is that your position, that the only way you can commit a common law assault with the objective of avoiding apprehension is violent?
That's correct.
Right? That's the only way you win, right?
That's correct, Your Honor. That is the government's position here.
Well, let me give you a hypothetical then. Let's say the police, you would agree that the person who is the object or the subject of your assault doesn't have to be the person who's trying to effect the arrest. You agree with that?
That's correct, Your Honor, and we do
All
see
right,
that.
so here's my hypothetical or counterfactual, whatever you want, either way you want to have it. Everything's a hypothetical. You're running from a police officer. and you're trying to avoid the imminent arrest, and a citizen is there standing and blocking the door, and you say to her or him, get out of the way or I'll hit you in the head. Is that a common law assault?
Is it a common law assault?
Yes.
Yes.
Yes. And was it for the purpose of trying to avoid apprehension?
That's correct, Your Honor. I
Well,
think it would be, but I think there's an important distinction to be made here.
Go ahead.
The assault needs to be directed at a victim, and that's the first point. The second point is
the
that
victim is the person who was standing in the way at the door. And you just said that the victim doesn't have to be the person who's trying to affect the arrest. The victim is clear in my hypothetical. The person standing in the door. Get out of my way or I'll beat you, because I'm trying to get out of the way so I can get through there so I can avoid being arrested by the police officer who's behind me. Then go ahead and tell me go ahead.
Well, Your Honor, I think the problem here is that the intent to prevent lawful apprehension assumes that the victim is the person who is trying to effect an apprehension.
And you just told me it didn't have to be.
But you acknowledged that wasn't the case.
Right. Are you changing your answer now?
No, I'm simply saying, for instance, I think by way of analogy, we can look at the Barrios case. In Barrios, it was not, there were defendants who were pushing against law enforcement for the purpose of allowing a different defendant to escape. Now, this, in the government's view, does qualify under the statute. And the reason why is because the assault was done with the intent to prevent lawful apprehension. You only get the intent to prevent lawful apprehension because there's an active means of assault occurring with the intent to allow someone else to escape.
And that actus reus, the actus reus doesn't have to be any higher than common law assault. It's the minimal. You're right. All these things that are aggravating are included. The question is, when we do the categorical approach, is what is the minimal actus reus that would still qualify for a conviction? And that's what my hypothetical is asking you, is that a common law assault, which you conceded, has occurred when you say, get out of the way or I'll hit you in your head. Okay, that's a common law assault. And it was for the sole purpose of avoiding apprehension.
So, Your Honor, I think the hypothetical is flawed, though, because
it's what my hypothetical is flawed.
I think it's flawed in terms of satisfying the statute. Okay. I don't believe that satisfies the statute for the reason that the intent to prevent lawful apprehension elevates the actus reus. It transforms the actus reus into something that would be capable of combating what is apprehension. And I think that's the sort
Isn't that capable? If I can frighten him or her to get out of the way, that's capable of me getting away. Listen, the only objective of avoiding apprehension is to get away without being arrested. Unlike robbery, you want to take something. Unlike murder and maiming, you want to hurt someone to an extent. You don't want to hurt anyone. All you want to do is get away. And the question is, Maryland has said a common law assault is enough. See, that's what you're trying to make this more than what's necessary. You think, oh, it's got to be a shootout or smack a police officer. No, it is just to avoid apprehension.
Your Honor, I think that the victim there, though, I don't see how the victim is affecting apprehension in your hypothetical. And that's
okay. If the person says, I'm not going to move because I want to help the police officer capture you. That's not, the victim is not involved in the apprehension. How is that not?
Well, then I think a threat to strike that person I think that actually would qualify under the force.
That's what I said.
It includes threats of force.
Didn't I say? Oh, so that's an act of force.
I think in the adjusted hypothetical, yes, it would be. But and I think that's the important point to take away here is we're analyzing the level of force that is needed. It's not it's not necessarily the minimum conduct that you can hypothetically think of. It has to fall within assault with intent to prevent apprehension, and all of those factors need to be satisfied. And we see from the Maryland case law that at least within the case law that we have before us, every case that we have before us involves a level of force that is beyond de minimis force, Your Honor. We have in
Yes, but
Barrio,
don't we have the Maryland courts saying that all you need is the minimum force, all you need is assault, common law assault?
so I don't believe we do, and
We don't, huh?
I don't think we do. And the reason why this is different than the situation in Aparicio is because in Aparicio, the court determined that the Maryland offense of resisting arrest did not qualify as a force clause crime of violence because Maryland's highest court explicitly held that nonviolent physical contact satisfied the statute. We do not have that here. In Hall, the Hall court, in Hall, it did not say the offense was identical to resisting arrest. It simply pointed out that the non-existent crime of preventing lawful apprehension would certainly be punishable by more than 1 year if resisting arrest was also punishable by more than 1 year. This says nothing about the minimum conduct required to satisfy.
Wouldn't be sufficient.
Spitting.
Is it a common law assault?
Is it a common law assault, spitting? I believe it is, yes. Yes, Your Honor. Things like spitting, throwing water, even pulling free are simply not enough to show assault to prevent lawful apprehension.
Well, I don't understand why that's so. Okay, so let's take the spitting, or you have a whole thing of water and somebody's in your way and you throw it at them and you're running away from the police. I don't understand what's missing.
I think what's missing here is that this type of hypothetical enters the realm of legal imagination, which we're told that we should not do under Docter and Moncrief. To say that it's plausible that someone would say spit in an officer's face.
I think that's plausible, don't you?
Well, Your Honor, I think certainly a person could and probably has spit at an officer during the course of a lawful apprehension. Now, that doesn't mean, I think it's a leap to intuit from that the specific intention to prevent lawful apprehension through spitting. Put another way,
the purpose of it. I mean, when you think about it, I don't think it's something that could be uncommon. I mean, any effort, if you don't have any other means to do it, he's using everything that's within his power. And maybe the spitting could just distract the officer and allow him to get away or do something else there. I mean, I don't think it's a far-fetched hypothetical. The question is, does it fit within the definition that would allow it to fit under the statute?
And no, Your Honor, I don't think it does. And I would disagree that it's not a far-fetched hypothetical under even the language of the statute. Spitting is not a way that you could successfully prevent someone from lawfully apprehending you.
So speak to the Jones case, the South Carolina case, where you had to spit on the blood of the officer's boot there.
So in the Jones case,
we said in that case that the jury convicted him of assaulting, beating, and wounding an officer while resisting because the defendant spit blood on the officer's boot.
And I think the reason why Jones came out the way it did was because the court said that mere attempts to touch an officer in a rude or angry manner would satisfy that statute. And I think that's very different than here. And this gets us back to the realistic probability test that was. Let
me understand what you just said. Mere attempt to touch him in an angry manner. So it's the angry manner that differentiates?
Well, I think I think what differentiates it is that the court had actually applied it to a situation like that. So that the court had applied that conduct to the statute beforehand, the South Carolina courts. Here we don't have that, and there's a reason we don't have that. It's because Maryland courts do not recognize something like spitting as qualifying under the statute. That type of conduct would not satisfy the offense. And
what tells you that?
What I think that the lack of cases showing that type of conduct tells that. I think that demonstrates it, and that actually is what the courts have directed, how the courts have directed us to analyze this. Again, we cannot apply legal imagination. And just another point, I think Stokeling would also have some bearing on this, because we could say that theoretically someone could attempt to spit at someone in order to rob them as well. However, that is outside of the realm of what would realistically occur. And I also
let's be so we make sure we're talking about the same thing. Are we talking about state law in terms of determination of whether a crime of violence exists, and consider that in light of Johnson 1, where the court made it clear that the question under this particular act is a question of federal law, not state law. And in Maryland, just the punishment alone converts it, but that's not necessarily true under federal law. I mean, we look to the level of violence.
I think I would agree with that, Your Honor. However, I do believe there is some interplay between there's some interplay between the state and federal law. And here we look to the state to see what types of conduct would satisfy the statute, and whether the statute would, for instance, permit certain types of de minimis conduct. And in the state, we don't see any de minimis conduct here.
Councilman, when you keep saying that, we do, because when they said that it includes common law assault, you see, I don't want to, go through some jurisprudential talk about it, but the problem with a lot of these cases is this: when states have these criminal laws, they're not trying to find predicate offenses to add on to enhance federal sentences. They're trying to protect their people. And for you to say it's far-fetched to protect the public, they don't want people to run. That's why they have an interest in saying the person who's on the street, who's common law assault, get out of my way. That's very common. People are going down the street to get knocked down, that people can have heart attacks, they're elderly people, they're children. They don't need violence. They want to make sure people know if you're fleeing, then you're subject to this statute. But that doesn't mean it meets the federal definition of the violence. It's like we're trying to shoehorn these things to enhance sentences. But states are trying to protect their people, and they don't want people to run from the police. And you are at risk when you come in, threaten people and say, get out of the way, and you bump them hard, those kind of things. It may not be forced, but it's something that the state wants to protect, and they have every right to do so to protect the people in Maryland. But that doesn't mean it matches the federal. Why there's so much angst here to shoehorn these cases? They're not meant to. The states have a different objective when they do that, when they pass their criminal statutes.
Well, Your Honor, and I see that I'm coming up on only a minute left, so I think I would wrap it up if there's not any more questions. But one last thing I would say is that it's not simply running away from, say, a police officer that has been criminalized. There would be no point in distinguishing assault with intent to prevent lawful apprehension from something like resisting arrest, which the Maryland state legislature did. And in so doing, assigning more severe penalties if it just encompassed the same type of conduct that say running away from the police would encompass. Certainly that was not the intent of the Maryland legislature to create surplusage here. And we also see this with the maximum penalties that are associated with those two statutes. Assault with intent to prevent lawful apprehension has a 10-year maximum, and resisting arrest in its current form has a 3-year maximum. So I just would conclude with that if there are no more questions from the panel.
Thank you, Mr. Stewart. Mr. Neal, you have some time reserved.
Thank you, Your Honor. Just a few points. I think I can be pretty brief. I'd first like to address the government's surplusage argument and sort of what is the difference between this offense and resisting arrest. There is a difference between this offense and resisting arrest, and it points in our favor. Resisting arrest requires that the defendant know that a law enforcement officer is attempting to arrest them and resist by force. Claggett tells us that assault with intent to prevent lawful apprehension can, by its plain terms, be committed through battery against a person who is not a law enforcement officer. It could be a shopkeeper, it could be a store security guard. And so the statute is broader than resisting arrest in the scope of people against whom it may be committed. And so I think the government's surplusage argument here fails. Second, I think the colloquy demonstrates apparitio soraya here provides the governing legal framework. Sitting on banc, this court said, it doesn't matter what the factual conduct was in the cases that the government cites. In apparitio soraya, the court colorfully said the government had a raft of cases, and there was no case where the defendant was able to show that resisting arrest was committed through offensive physical contact. Nonetheless, this court relied on plain statements from the Maryland courts, and we have those same sorts of plain statements here. We have them from several courts. And I would note that the government's argument didn't focus on what the Maryland courts have actually said about this. It is about sort of hypothesizing about how we should interpret the statute and what this potentially elevated form of assault must mean. It's not grounded in how the Maryland courts have approached this offense. And I would note that Claggett referred to the plain text of Section 386 as encompassing battery. So I don't think that the Maryland courts even view this as a close call that simple common law assault or battery satisfies the statute here. Third, I'd just like to offer another hypothetical that I think may be illustrative, just in case it's helpful for the panel's consideration. I would note, again, under apparitio soraya, we don't need legal imagination, we don't need hypotheticals, but given the breadth of the statute, I think it could easily and very plausibly be satisfied by a person who enters, say, a convenience store, removes an item from the shelf, attempts to leave the store clerk, the owner, a security guard, tries to stop them from leaving, and the defendant commits an assault of the kinds the panel was bringing up in your questions. They could throw water, they could throw a slushie at the person, they could spit at them, anything to give that person pause while you try to get out the door, or while your friend tries to get out the door. We have Hall, Claggett, and Barrios telling us how Maryland courts view this statute, and I think that really sort of ends the inquiry here, just as it did in apparitio soraya. I'm happy to answer any questions, but otherwise I would just conclude there, Your Honor.
And so I have a question to ask you that doesn't have anything to do with this case. I see that, did you clerk for somebody in the Fourth Circuit? How did you get here? That's what I'm asking you.
I did not clerk for somebody on the Fourth Circuit, Your Honor. We have been working on this case with the Federal Public Defender's Office.
Well, thank you. Appreciate your argument.
Thank you both for your arguments. We appreciate it very much. We can't come down and shake your hands in our normal Fourth Circuit custom, but please know nonetheless that we very much thank you for your arguments, and we hope that you'll be safe and stay well. Thank you, counsel.
Thank you,
Your
Pat.
Honor.
All right, we'll proceed to our next case. Mr. Ballinger.
Thank you, Your Honor. May it please the court. I'm the director of the Appellate Litigation Clinic at the University of Virginia School of Law, and it's my pleasure to introduce Mr. Benjamin Lerman and Mr. Jacob Larson, who will be presenting argument for Mr. Starbuck. Mr. Lerman will handle the opening argument, and Mr. Larson any rebuttal.
Thank you.
Your Honor, and may it please the court. The board acted as the final policy-making authority when it reviewed Starbucks' suspension and upheld it on changed grounds. That decision constituted an official policy for which this board could be held liable under Section 1983. The Supreme Court's precedents in Pembauer, Proprotnik, and Jett, and this court's decision in Hall make it clear that even discrete one-off decisions can represent official policies if they are made by an official or government body with final policy-making authority under state law. Under Virginia state law, the board is the final policy-making authority with respect to short-term suspensions. It reviewed Starbucks' suspension and unquestionably had the final authority to remove it from his academic record. That suspension was a violation of our client's First Amendment rights, accomplished through a process that violated his 14th Amendment right to due process. The board's action was an official policy that violated Starbucks' rights. Therefore, the complaint did properly allege a Section 1983 violation by the board. The district court focused instead on whether the board's action was taken pursuant to a pre-existing official policy or custom. but did not recognize that the board's decision itself constituted an official policy. As Pembauer and Proprotnick made clear, and this court reiterated in Hall, Section 1983 applies where the actions of lower employees are officially sanctioned or ratified by the final policymakers, in this case, the board. A single violation is sufficient to invoke Section 1983 liability, so long as the decision maker possesses final policymaking authority with respect to the action ordered. Applying the Proprotnick principles, it is clear that the board's action constituted an unconstitutional policy for purposes of Section 1983 liability. The board.
So when we're talking about a Monell type liability for municipalities, the district court seemed to consider that there's no express policy here. And tell me where the error is in the district court making that determination, and because you seem to be going to another prong there that you think maybe the district court should have considered.
Well, yes, Your Honor, I think the crux of the error the district court made was it was looking for a pre-existing policy that the board was acting based upon, when in fact the decision itself constituted a policy. Under Section 1983, a single decision can be considered a policy if it's made by the final policymaking authority under state law. And under Virginia law, the board is the final policymaking authority with respect to short-term suspensions. They reviewed this suspension, considered the facts, and chose as the board to take action ratifying that suspension, and they changed the grounds for that suspension. So that action alone, regardless of whether there was a pre-existing policy, constitutes a policy. And we see that in Pembauer, and that those principles were reiterated in Proprotnick and Jett. And we see that again in Hall, where the school board's decision to fire a teacher itself was a decision that constituted a policy. So
to be clear, you are saying essentially whether it's a policy or a pre-existing policy is one way. If I'm understanding you correctly, you're saying the fact that the board was a final policy-making authority making the decision was sufficient in and of itself.
Yes, in this case, the word policy here is really, it could refer to a policy that exists over numerous decisions that's been followed over a long period of time, or it can exist for a decision that's made by the board. Ultimately, Section 1983 is meant to ensure that we're holding final policymakers, or the board, we're only holding municipalities responsible for the decisions that they themselves make. And in this case, they themselves made the decision to ratify this suspension. So,
but of course, you have to allege this, or your client has to allege this in the complaint, right? And what paragraph of the complaint do you rely on?
The complaint makes clear that
just tell me the paragraph, and I'll decide whether it makes it clear.
Absolutely, Your Honor. I will pull it up right now.
Because a lot depends. I thought that what you were relying on is the school suspended Jonathan with approval from the school board.
Yes.
Is that the most direct thing you have?
So if you
look to a school board's decision.
Yeah. So if you look to Joint Appendix 13, the complaint alleged that the board considered Starbucks' appeal and found the suspension was proper. That's JA 13, that's paragraph 28, and on JA 14, paragraph 34. So the complaint does make clear that the board looked at this suspension and did ratify it, which is what.
I'm sorry, tell me again your citations.
JA 13, paragraph 28.
Yes.
And JA 14, paragraph 34.
I don't see, upon expiration of the allotted 30 days, the school board's policies in dealing with it, no response was received and no communications made.
When the defendant responded to the written appeal, the defendants found the suspension was proper, but altered the cause, finding that the plaintiff was a classroom disturbance. So the complaint clearly alleged that the board found the suspension proper.
The complaint doesn't say, and I don't think you maintain, that the school board issued something that clearly said that this was their action. So what you're saying is that this is sufficient. So each time you tell me that is clearly, you sabotage yourself. But being that as it may, let me just see. When the defendant responded to the written appeal in May, the defendants, apostrophe S, who are the defendants here?
The board, Your Honor.
Defendants found the suspension was proper.
Correct.
So, and this is a pro se complaint, is that right?
That's correct, Your Honor.
All right. Thank you.
No, I apologize for any confusion.
No. I was just being a judge.
As is, you're right. Applying the Proprotnick principles, it's clear that the board's action constituted an unconstitutional policy for purposes of Section 1983 liability. The board itself found Starbucks suspension proper and altered the cause to classroom disturbance. And the board is the final policymaking authority for student suspensions under state law. To get around those facts, the board has tried to append another requirement for Section 1983 liability not found in the Proprotnick principles, namely that the board cannot be held liable unless it was an active participant or moving force in the initial decision to suspend Starbucks. But the Proprotnick principles, adopted by a majority of the Supreme Court in Jett, include no such requirement. Rather, both Pembauer and Proprotnick made clear that when the final policymaking authority reviews and approves a subordinate's decision, their ratification is chargeable to the municipality. Certainly, the board's participation and approval at every stage of the suspension would be sufficient to establish liability, but it is not necessary. There is no requirement that the board be involved in the initial decision by lower officials to suspend Starbucks. The board's independent.
In the Supreme Court cases, you're going to be a good litigator because you just talk right along. It's hard to interrupt you. So the Supreme Court cases in which you rely do not involve this higher authority, the equivalent of the school board being an active participant in the assertedly unconstitutional action, but simply approving it. Is that right?
Yes, there's language in Proprotnick that essentially says that if the final policymaking authority sanctions or orders upon review. So, for instance, in Proprotnick, the court acknowledged that the Civil Service Commission was the final policymaking authority had they chosen to review an employee transfer. And obviously, they wouldn't have been the one that initiated the transfer, but if they had chosen to review it, they would have been the final policymaking authority. So there's no requirement there, and certainly no requirement in the stated principles from Proprotnick that were adopted in Jett and are reiterated by this court in Hall. There's no requirement.
But if we can go back to Proprotnick, which I was trying to avoid saying. Anyway, if we can go back there, then what I guess you're saying to me is that there wasn't action. And so it's not exactly like our case because you maintain that there was action by the school board. Is that right? I mean, it's the way you described the Supreme Court case. The court was saying if they had acted, they would have been the final decision maker.
Yes, well, I think it's very common for municipalities, local governments, in all places to give a certain amount of discretion to lower officials, but reserve the right to intervene as the final authority if they choose to do so. And
okay, so what I'm asking you is the intervention necessary to make them the final decision maker for purposes?
Yes, Your Honor. And then the fact that
you didn't have that decision, that situation in Proprotnick, right?
Correct. And the court essentially said that because they did not act, no final policymaking authority acted. In that case, the plaintiff lost. But had they chosen to intervene at that point, they would have opened themselves up to Section 1983 liability. And here the board did choose to intervene. And as a result, they have opened themselves up to Section 1983 liability because they have spoken as the board and as the final policymaking authority. And that constitutes a policy for purposes of Section 1983.
Counsel, you said the board chose to intervene. Wasn't that a part of their due process effort to intervene or to make a decision?
Your Honor, that may be true. The record is silent on whether the board was required here to intervene. There could be a policy that they have that they must respond to written appeals. Our client made a written appeal to the board, and they did respond to that appeal.
That's what I'm saying. In this case, you say that they chose to intervene. that's a little bit of an overstatement there. They were responding to your client properly, asking them to review it. So now,
Certainly.
do you equate a decision making under those circumstances to a policy? Weren't they trying to decide an incident that already had happened, in fact, punishment that had already been meted out, and trying to make a decision as to whether or not those facts constituted something? You equate that decision-making process to a policy?
Yes, Your Honor, and a few points on that. First, the language in Proprotnick and Pembauer is clear that where a final policy-making authority subjects a lower decision to review and then ratifies or sanctions that order, they are then liable for the consequences of that order if it violates the constitutional rights, my client's constitutional rights. Secondly,
they didn't ratify nor sanction it because the grounds on which the suspension was carried out, ultimately they said no. It was a disturbance.
Well, Your Honor, and
it was not a threat. Is that correct?
Yes, Your Honor.
But then you're not arguing your argument is counter to the facts of your case. Right?
Well, I think there is, and I think the discovery would be very helpful here. There is some question over whether the board changed completely the grounds for this from threats to classroom disturbance, in which case they would be acting independently, in which case they're even, I think in both scenarios, they're liable for their action, whether they ratify.
The board can look at the facts and say, under the facts here, while it does not constitute a threat, we have determined in our adjudicative function that it constitutes a disturbance.
Certainly they can, Your Honor. And in that case, they would still be open to Section 1983 liability, as it's still an action that constitutes a final policy by the board.
So that means that under it would be a thin protection under Monell to say that every time something occurs that they have to opine about in a review circumstance, they're putting themselves on the line and saying their policy is at stake if they look at the facts and say it is or isn't. I mean, Monell would have very little. It would be a tiger without teeth, wouldn't it?
Well, Your Honor, that if they review the decision and approve it as they did in this case, at that point they are articulating policy as the board that the student should be suspended in this case.
They're not approving policy. They're looking at facts to determine whether or not it constitutes. You would agree that a school can discipline a student for threats, correct?
Certainly.
You also agree that they can discipline students for disturbances, correct?
Certainly.
Well, when matters come before them in terms of the factual allegations of what happened, why wouldn't the board just be in a situation like a court? I'm trying to determine policy would be, listen, you can suspend them for wearing a T-shirt that says, America's a great country. Then that would be a policy that would set forth broader parameters. But you just conceded that disturbance and threat are both within the parameters of New Jersey, in the PLO, in loco parentis and all those things like that. They still have, but don't you circumvent Monell by the extent of your argument?
Ultimately, Your Honor, I feel that the decision to discipline him under the facts of this case, they essentially were saying that the speech that my client gave, or that my client engaged in, was subject to punishment. And we feel under the First Amendment that was protective speech. And by reviewing and approving that suspension, they violated his rights. And the suspension itself, and I see that my time has expired, if I could just briefly close. Sure. One of the great harms to my client here is that this suspension remains on his academic record and will appear when he applies to graduate schools, potentially in jobs in the future. And the board ultimately had the final authority to remove that from his record and chose not to. So that injury was ongoing and was ultimately the result of the board's decision here not to remove it. So the injury suffered here is absolutely a result of the board's action and therefore should be subject to 1983 liability. And with that, I will close. Thank you, Your Honor.
Let me ask you one last question on what you just said there. If the board at this point would acquiesce and remove it from his record, would that end this case?
Yes, Your Honor. That would be that is the remedy that we are most seeking in this case.
All right. All right.
Thank you, Your Honor.
Thank you. Mr. Capps?
Thank you, Your Honor. May it please the court, Jeremy Capps on behalf of the Williamsburg James City County School Board.
Sir, could you address what my colleague just asked? Would the school board just consider withdrawing this suspension?
So
or removing it from his record, essentially.
Yes.
I mean,
Yeah.
in light of what's here. And the reason it's being brought up is, if something happens adverse, this continues to move along. It just seems to me what's being asked, and I don't know, when you look at the conduct that actually occurred here, it's really hard to find something that happened here that was in all candor, and I think we probably all look at it and says probably nothing should have happened here. And the question is maybe it's a point of pride, or maybe it's something here that's going on, but why wouldn't you just remove it from the record? And then that, as I just heard, that ends this.
Well, Your Honor, one, I can't speak to that issue because that hasn't been presented to my client, although it's certainly one that would be considered. If we look at the amended complaint, that isn't the remedy that Mr. Starbuck asked for. He asked for an injunction requiring the school board not to enforce certain policies. And he also asked for a declaration with respect to declaring that the school board, through its policies and the high school through its actions, violated and continues to violate constitutional rights. So
it seems to me that if, in light of, and I respect where you're going from in terms of what's being asked for, sounds like to me he's no longer in that situation in school or whatever, but it seems to me that at least at this point, there's something for you to consider possibly. Is the question that if in fact that is the case, that we're simply removing from the record and that can be done, you just might be able to take care of this case before we put a lot of work into what we're doing here. But go ahead and proceed.
That's understood, Your Honor. And I can discuss that with my client if that's the position of Mr. Starbuck as it goes forward. And I think that goes to the point that on our motion to dismiss, and the district court agreed that the policies that were alleged in the amended complaint did not state a cause of action under Monell. And I hear now.
Well, I don't know that the suggestion that you remove this from the records, it goes one way or the other towards the Monell claim, if that's what you're suggesting.
It is not. What I am saying though is, based on the facts alleged in the amended complaint, it was our position that the allegations could not and did not state a Monell cause of action against the school board, and the district court agreed with that. That the policy.
No, I do understand that, but if you went back now, who would be making the decision? The school board, right?
It would
They
be.
made the decision to begin with.
It would be the school board or an authorized representative. Yes, Your Honor.
Well, it couldn't be without the consent of the school board, right?
Correct, Your Honor. But what I hear now on in the briefs and on appeal is that the Mr. Starbuck no longer relies upon the policies that were alleged in the complaint.
Sure, he does. All we're doing now is talking about the Monell point, I thought. And his whole argument is that you can have a Monell action when the final decision maker makes the decision and is the person in charge, as your school board is.
Correct.
That you don't need a separate policy, that the school board, the final decision maker, is the person that's making the decision, and then that is the policy. That equals a policy, a pre-existing policy. So how does settling the case affect that?
I don't think that it does, Your Honor.
Okay, then I misunderstood your argument.
Yeah, I don't think that it does, and if I suggested that, I apologize, because that was not my point. I think there's two separate points. One is certainly we can address the issue of with Mr. Ballinger if that is the request to resolve the case. If, however, the case were to
let me also just sort of look at it in terms of, I don't know what the plaintiff's situation is, but apparently he proceeded in this matter pro se. This court has kind of looked very liberally at complaints filed by pro se litigants, and we look at it in terms of all of the facts. Now, what we do know is, I think we could probably, it's established by law that the school board is the final policy-making decision, the authority for policy-making. The question is, did it make a decision? May arise. It seems back where we're going back and forth on that. And you probably could get something out of it. We know they did certain things. They even intervened in participating in this post-suspension meeting at the school with the student. And there are certain things they did do. And when we look at this, I'm just saying, when you look at a case like this, and then you look, and we're talking law, and we're dealing with in terms of policy, but then it is not wrong to go back and look at what actually did happen here, and why doesn't someone just fix this? This case screams for it. I mean, it's not like you've got, who wants to defend themselves against what this student said in the context of it and the conduct that occurred to him? And I don't know what the student's situation is, but I noticed his brother represented. He's from a single mom. And I just can't imagine this happening to a child who goes to school who probably has a different situation. I don't know what his economic situation, but it doesn't sound good. And he's put in a situation that it would appear to me most students with vigorous parental and significant representation would not have faced this kind of situation. And I don't know what the situation is. As I say, I don't know about why it was the brother. I know initially the brother was in it, and the brothers dropped when it became of age. The defendant came of age. But there's some facts here that are not very favorable, even if the school board prevails. That I think you just, I don't know, maybe it just seems to me you just ought not to. This doesn't sound like something you should fight for if, and like you say, you don't know at this point what is on the table. And it sounds like to me, if that's on the table, that might be something you would consider. And I just throw that out because I think that's important with this case. And we like to resolve cases and move forward and be adversarial, but there are points in which you are fighting a battle that it doesn't, even if you win, you don't win on this. And I don't know if you disagree with me on that or agree, but I'd like to hear it.
Well, I appreciate your point. The issue though, for schools is an important one, and a societal one, which is teachers and administrators are put in very difficult positions when there are discussions or talk about violence in schools, and they have to act.
Speak to this violence that you say is happening, and all that you say seems to indicate some big threat. I want to look back at the facts of what this student actually did. He was, I guess, describing. I mean, this isn't a situation where he makes a threat that directly. You've really got to read something into this to make something out of it. Well, and the context of it. So, I mean, what you just described, I agree with it. You school boards have that authority. But what happened here probably happens every day in a classroom in some kind of context. I mean, it seemed to be rather light, but the reaction was pretty severe.
Well, I would disagree, Your Honor, and here's why.
Well, tell me, let's make sure we're disagreeing on what did he actually do? Describe what happened.
Right. So it was the day after the school shooting in Florida, and that has to have some context. Right.
Sure.
It does.
So it is concerning that we had a school shooting of multiple students in Florida. That the allegation is he was discussing that shooting in class, talked about that
with whom?
With other students, talked about the way that the shooter could have accomplished more damage, talked about
What did he say? What did he say? Not talked about. What did he say? Now
The
that's
allegation.
disgusting. There are a bunch of kids in school just talking about a shooting that happened somewhere else. And what did he say?
The allegation, and that's a JA 10, number 11, is that he made remarks questioning the intent of the shooter, stating that the shooter would be capable of more harm had he wanted to, noting his possession of explosives, and considering the time the shooter was left alone in the building unchallenged by local law enforcement.
We have,
False about any of that? What's false about anything he just said? That someone says, well, you know, that guy down in Florida, he could have done more damage, and he had explosive. He could have done that. What's threatening in giving an opinion about something that happened down in Florida to some fellow students?
Well, again, in the context of a school shooting where people are on edge for copycats, and that's just the reality of what happens with school.
Do you have any
shooting.
indication that situation existed here?
What we
Was there
had,
any indication that there was some copycat or I mean, all he got is an opinion. He just make an opinion. This guy down there could have done more damage. He had explosives. He could have done this. And from that, you leap to, well, that's a threat. And now let's suspend.
Well, what I do say is a teacher overheard those remarks and was concerned enough about those remarks to not only report it to her administrators, but also the police. And
well,
so,
and what did the police find?
So the police investigated, sure,
Right.
under the allegations, and determined that there were no criminal charges.
No threats,
said it was
not
nothing to
violated Virginia law.
Right. So no criminal charges, but that doesn't mean that it can't be inferred from the allegations that the teacher who overheard those remarks was concerned. And the law isn't that school administrators can't issue a suspension, a short-term suspension for disturbances in the classroom. There's a difference.
Well, counsel, suppose the student had said, while talking to his fellow students, I can't understand why he did a thing like that. I can't, and said that 10 times in a row. I can't understand why he did a thing like that. Couldn't the teacher be concerned about the student or about what he said?
I suppose, but I think that that's a different context than what the...
No, the context is in her mind, because that's what you basically saying. You said this is justified because she was concerned, whether it was a threat or not, she was concerned, and maybe so. But you could be concerned there. You said he repeats, I don't know why he did it. So you're concerned. Well, you take him down to the office. Are you okay, son? Are you all right? Are you concerned? You bring in the police officer there. But then it goes to you suspend him for 2 days for something that clearly is no threat. Now, concern, a teacher, you can look, that's how teachers are, at least when I was in school. You could have your head down on your desk and weepy. And the teacher said, I'm concerned about you. Because that's what we love about our teachers. They're concerned about their students. But you can't transport concern to the point now you're going to kick the kid out of school for 2 days. That's what I'm
have it on his permanent record.
On his permanent record too. Forever he has a scarlet letter on literally on his record.
Well, but again, it goes to what the school and the process that it goes through. The teacher is concerned, and I also note in the amended complaint the plaintiff alleges that at one point in the discussion, and this is in the first paragraph of the amended complaint, he noted the possession of explosive devices by the shooter, the use of a fire alarm to lure students out, and noted the time it took for law enforcement to enter, in addition to what I read earlier. That's different than saying, I'm not sure.
Wasn't that all that was reported in the news? He didn't know this stuff. He'd never been to Florida. He's just saying what the guy had explosive. He took time to do all. I mean, he is really saying it. let me tell you, there's something going on here, and this doesn't make any sense to me because I just cannot believe. I don't know this student, but there's something about this student that causes this thing to be elevated. A student that's a model student, I'm not saying he is or comes from an established family. I do not believe anywhere in the world this would have happened. There's something about this student while this was taken to this level, and maybe the record doesn't bring it out, but it has an air of there's something going on here. You don't do a student like this unless you have some reason or something about that student that makes you think that student would do it. And what is about this particular student? Because in an average student, you would think, well, that's just talking about it. But what about this student made this teacher and the board and others think we ought to suspend him for 2 days?
So again, that is not alleged in the amended complaint. And so
there must be something, but tell us, got to be something, because you can't believe any, if it was one of our kids or someone that you wouldn't think for one moment, you'd fight this for all day long. That kid would never get out of school. And I'm trying to figure out what is it about this student that caused this kind of reaction to call the police. And even after the police comes and says, you say they say those criminal charges because that's what they do, but they did an investigation. Really, they didn't. If they thought it was a threat or anything, they would have to act, because the kind of seriousness you're talking about, that's not the school board's concern. That's police, law enforcement. If he is talking about or disrupting things, talking about a shooting, and you think there's a chance of it, that's law enforcement. They looked at it and just said, oh, this is nothing. But someone in that school system, felt like because of this particular student, there's something about him that's really troubling. And maybe the record doesn't show it now, but at some point in time, that has to come out.
So the record doesn't, as alleged in the amended complaint, but what we do know from the amended complaint is that the local administrators of the high school followed the Supreme Court's guidance for due process in short-term suspensions, because they brought him in. They had him talk with a counselor. They had him talk with a principal. They, according to the alleged complaint, had him talk with a psychologist during the day that this was reported. And as a result, they issued a 2-day suspension, a short-term suspension, and called mom and told her about it. And so the decision that the school administrators made at the time did comply with the process according to the alleged complaint, the due process requirements of the Supreme Court.
One of the school officials said that he was really suspended for his own safety.
The allegation.
I'm saying in terms of what the vice principal said there, didn't he say he suspended him for his own safety?
No. So what
against retaliation by other students?
No. So what the amended complaint says is he was held for 3 class periods during this initial investigation. He calls that in-school suspension as alleged in the complaint. The complaint then alleges that the assistant principal, and I'm on JA 11 at 18, the assistant principal contacted his parent, notifying her of the out-of-school suspension. And then on the next page, JA 12 at 19, it says, when questioned about the quote unquote in-school suspension, that was the 3-hour period during this, where he talked with the counselor and the psychologist, the principal said that he was in this 3-hour in-school suspension, this period, for his own safety. It doesn't reference the out-of-school suspension. The allegations are mom was given the reason or told of the out-of-school suspension. So it's 2 different things. I see that my time's up.
Sir, I take your point about procedural due process, but doesn't he have a First Amendment claim?
So he doesn't. One, the court, the district court agreed that the policies in play, as alleged in the complaint, there were 2 policies. One, that we didn't comply with a long-term suspension policy, which is not the issue here. And two, that there was some form of policy to continue investigations, but no facts to suggest that did not rise to a policy of the school board that can.
Yeah, but this all goes back to your Monell argument. Suppose you lose the Monell argument, then he's alleged First Amendment claim.
Well, if this court were to decide that there was a Monell issue, then that the school board engaged in a policy that implicated
the school board's decision, because this is the argument. The school board, because it is the final decision maker, what it decides is the policy for the institution. Right. So taking that as what would be the conclusion.
Yeah. So it's our position, and as we set out in the brief, that's not the case here because
I know it's not the case. I'm asking you to assume that that's what we hold. Then, if that is what we hold, then hasn't he alleged a First Amendment claim?
If you hold that the school board made the final decision on his suspension, then yes, it could be a policy maker. However, Judge Gregory, as he pointed out, it's just a review of the decision. The decision was already made by the school administrators.
Yeah, but we're speaking to cross purposes. You may be totally right, but suppose you're not. Suppose he has alleged a Monell claim against the school board. Then does he allege a First Amendment claim?
Yes.
Thank you. Okay, appreciate that.
I want to be clear on that, where it was going. What Judge Motz is alluding to is that, and maybe the trial judge seemed to have gotten confused, to allege a claim against a municipality, you can have an express policy, but there are other ways in which you can get municipal liability. It's an or, and that or that she's referring to is through the decisions of a person with final policy-making authority. The law is very clear that the board is a final policy-making authority. Then when you say they made a decision, that's municipal liability. But whether it constituted something that actually was another thing, but it falls under Section 1983. There are at least a couple other ways you can do it. Those two are not implicated here at all. But the trial judge relied upon the first one in saying there's no policy. Well, that's one way. But the point being is there's more than one way. And that's why that question went in that vein and asked, if we found that one, then would a First Amendment right? And your answer, I think, seems to me to be correct. Yes, it would be a First Amendment violation.
Alleged First Amendment violation.
Yeah, alleged.
Yes. Understood. And I guess the point, and we tried to distinguish this in the briefs, is this suspension already happened. It was a short-term suspension. It wasn't a ratification theory. The district court didn't get it wrong, and it wasn't alleged in the amended complaint this way. And if you look at what the amended complaint says, what he says is by changing the rationale, he didn't say it was a First Amendment violation. He said it was a Fifth Amendment, and even liberally construing that, what he's saying is it's a due process violation, and that's what's alleged in the complaint. And
that's why I asked you about the First Amendment. Anyway, I think as I say, I don't think we need to.
But then I apologize if I appear to be talking past you, and I was trying to answer your question, but our position is what was alleged in the amended complaint is not a First Amendment violation. They didn't allege that. What Mr. Starbuck alleged is by considering it and changing the rationale, we violated the Fifth Amendment, which is a due process under federal law, but even liberally construed a due process claim, not a First Amendment claim.
Mr. Couch, before you go, just would you help me on this? Okay, let's assume that it seemed like a lot of evidence, a lot of facts would point to that there's no policy really involved here, but it's a question of, as Judge Wynn said, the other side of how it can be effectuated by decisions or some otherwise being involved in it. It looks like now, and I think that's why it started like this with you, my dear colleagues and friends were asking about, ultimately, isn't this case now about the fact that it's on his permanent record? And the board decided that this was a disturbance, and their action is that it stays on his record. Now, would you agree for due process now here, was he given an opportunity to weigh in on whether or not what was at first told him to be a charge of threat, they decided now it constituted disturbance without giving him an opportunity to speak to that?
Well, what I think the allegations show in the
I'm talking about the facts of the cases, we know them. Didn't they, was he there, was he allowed to say, well, I'm here to defend threat, if, for example, or I'm talking about the threat charge, and then somehow it morphed into a disturbance, and without his having a chance to, am I right? Was he given a hearing?
So it's my understanding there was not a hearing. What he did is file a written appeal of the school administrator's decision, and the school board looked at his written appeal, and essentially they said it's a lesser version. They didn't change or create a quote unquote new charge that he couldn't respond to. He responded to the assertions, the allegations, and even the amended complaint alleges that it didn't rise to threats. What they said is, no, it's a classroom disturbance. So there's not a different circumstance with which he would have had to respond for due process purposes.
Oh, really? It's not a lesser included offense because they had the same charge. I said the same punishment. The disturbance was 2 days too.
Well,
right?
in the first paragraph, I'm sorry. Yes, you're correct that the suspension stayed in place. The allegations in the first amended complaint in the first paragraph said the remarks could not be supported as threats, but were instead determined to be a classroom disturbance. That's unlike the cases that the plaintiff, Mr. Starbuck cited in his brief, the Newsom Sixth Circuit case, where it was a long-term expulsion hearing and he was not provided with new evidence, a confession statement for that purposes. Here, there's not an allegation of new evidence or some form of new conduct that he needed to respond to.
Yes, it is, because when you say a threat, that comes from what you said. When you say disturbance, that means you've enlarged the fact there must be something that somebody else reacted to it. The disturbance comes from an outside, right? I mean, other students. There was nothing before him that he had that it was just a threat. You can make a threat in an empty room, and that's a threat, but a disturbance is something different. So implicitly, it must have been more. And see, if you get past Manel on the due process, the board is going to have to defend this on that. You can find, acting reasonably, you can find a disturbance from what he did. Right? That's what your client will be faced with. Finding a disturbance out of what he said. And there's no evidence that any student acted out at this point. So that certainly can't be done as a matter of law to dismiss it. You don't have any facts, you have to have discovery. All those things, don't you? That's the exposure your client may have. If we say at the very least on due process, we got a Manel question.
Right. And I would disagree. And as a short-term suspension, the allegations in the amended complaint show that he got the due process that was required. And that's the board's position.
And that might be a stronger case if all they did was suspended him for 2 days. But when you put it on his record forever, that makes it more than short term. You have made it by punishment long term. Because that's the rest of his life. People go back to his record in his school and say, look, you disturbed the school. That's the more in this case. It seems like it's not getting to you. That's the more. And the board is solely in the midst of that more.
And I appreciate that point, Your Honor. Again, when we were in the district court on a amended complaint that did not ask for that, but asked for an injunction and declaration, it's a different position.
Yeah, I
But
can appreciate.
No, of course, you are a lawyer too. You can think up, maybe they should have presented it, but you could, you settle cases all the time. One side presents one situation, another side presents, well, no, what about this? I hear you, but I'm not persuaded.
yeah, I understand, and I appreciate that position, Judge.
Let me be clear in understanding your statement. Did you, I think you said they did not allege a First Amendment violation. Is that what your position? In other words, they didn't say something to the fact that the decision made by this defendant had infringed upon the right of free speech as protected by the First Amendment of the United States.
So the allegation in paragraph 28 states that they found the suspension proper but altered the cause.
Is there a paragraph 34?
And then it says this action was in violation of the Fifth Amendment.
Is there paragraph 34?
Sure, and I see that. And
what does that paragraph say?
That says the defendant's decision for infringement or decision for suspension infringed upon the free speech rights, but based on the allegations in the complaint, in the amended complaint, that decision to issue this short-term suspension, and that was the position of the school board, and as we set out in the briefs.
Based on those allegations, it did because it put the sword of Damocles on his head forever. That's the whole point of prescriptive speech. You're saying now this is the result, allegedly, this is the result of what happens when you speak this way. It's on your permanent record. And believe me, for a student, that's a death penalty. That's about as much close to a death penalty as you can, because it's saying when you leave these hallowed halls, that will follow you. Just like people brag about being Phi Beta Kappa and Order of the Coif and all those things, it's the other side of that coin. This is the scarlet letter that Hawthorne talked about, the analogy. It is. That's the difference in this case. It's not just a short-term suspension. And the board is right in the mix of that. That's the key. I don't want to, we've gone to the over, but when you're responding to questions, it seems like, you don't get that part of it. It's not just confined to short term. And if that's a policy, you can take short-term suspensions and turn them into permanent records. That's another question too. Is that policy? So again, those are things that, as Judge Wynn alluded to, may come out if this case goes further. But anyway, so you know your case, and you obviously you've done well and argued that we've peppered you quite a bit here, and you held your ground well, and appreciate that. But anyway, we'll move on.
Thank you, Your Honor.
Mr. Larson.
Thank you, Your Honor. We just have a few points. First, we agree completely that threats is different than a classroom disruption. Those require different evidence in order to rebut them, and thus the Starbuck was denied his due process requirements under DOS. Second, his primary relief that he seeks is to have his records expunged. He's also seeking declaratory and injunctive relief, and we would have to speak with our client in order to determine whether he could, the settlement would be possible, but we are very open to having that conversation. Third,
Retreating from what your colleague said, that if they removed this from his record, the case would go away.
we would have to talk to him, Your Honor, about what he would really want, but it seems that his primary desire is to have that scarlet letter on his permanent record removed. And so as a result, that would probably finish the case.
Gotcha. Okay, thank you.
Your Honor. Furthermore, regarding the First Amendment claim, the board has failed to explain how Starbucks' statements as described in the amended complaint, which seem to be discussing a current event that unfortunately is important to a lot of high school students, meet that demanding standard under Mahanoy for speech that a school official can restrict. When we look at cases where school officials are allowed to restrict speech where it's found unprotected, like in Weinar, Winooski, and JR, there were concrete threats of violence targeting children for murder and rape. Or in Kowalski, a student created a website targeting another child, calling her a slut, and that had implications in the classroom for that student. Or finally, we have Hardwick, where a student was told to remove a Confederate shirt in a school that had a history not just of racial tensions, but racial tensions relating to clothing. This isn't those kind of cases. This is a case more like Newsom v. Albemarle, where the student was wearing a shirt that reminded a school official of the recent Columbine shooting, but wearing that shirt was found to be protected. Or in Tinker, where the students were protesting an ongoing war that was affecting other students and rendering those students and killing those students, but that was found to be protected. So from the facts alleged in the amended complaint, there's certainly more facts, more context that could be discovered if we were to get to discover it. But from the facts alleged in the amended complaint, we simply don't reach that standard under Mahanoy. Even if some of the things he said were perhaps cause discomfort, because as the court held in Mahanoy, there's always going to be discomfort that accompanies an unpopular opinion. And so that cannot simply be the standard for what loses protection. Regarding municipal liability, as the court held in Pembauer, the Supreme Court held in Pembauer, even a single decision can create municipal liability. In fact, the court said that would be contrary to the very purpose of Section 1983 to not allow it. And so a one-off decision like this by the board as a final policymaking authority, rendering a decision as the area where state law, Virginia Statute 22.1-277.04, grants it authority over, means that that decision can create liability under Monell. They are certainly protected in other capacities under qualified immunity. The employees of the school may not be able to create liability under Monell, but for that decision where they had final policymaking authority and that they made a decision as a result of that authority, they can create liability for themselves. And they did here through their violation of clear constitutional rights, Starbucks' constitutional rights, for punishing him for his protected speech, and then for giving him and rendering a decision that used another basis for his punishment than the one that he was told prior, and giving him no opportunity to respond to it. I am happy to answer any questions you may have, Your Honor, but if not, I believe we've said enough.
All right. Thank you very much, Mr. Ballinger and students. I note that you're court appointed, and I appreciate that. Not only is the assistance you give to our court, Judge Wynn knows it very well, being a part of that committee, and we really couldn't do our job without that. And even more so, you bring it to the academy and have fine young law students to come before us. And I say that the Cavaliers acquitted themselves very well today, as well as Mr. Capson representing his client very ably. We can't come down and greet you as we'd like to, but know very much that we appreciate your being here and for your fine arguments. So we wish you well, and please be safe. Thank you.
Thank you, Honor.
Thank you.
Okay. We'll proceed to our Ms. Pratt.
My apologies, Your Honor.
Oh, no problem.
This is my first argument by Zoom.
Welcome.
Well, we're all learning as we go, so
Yes.
Just jump into the frame. Go ahead. Go ahead.
May it please the court, Fran Pratt on behalf of the appellant, Jarrell Thomas. The issue presented in this case is whether a pre-apprendi 848 conviction qualifies as a covered offense under the First Step Act. The answer is yes, it qualifies. In a nutshell, our argument is this. First, the 2010 Fair Sentencing Act changed the penalties for violations of 848 involving crack cocaine. And second, in light of that change, the only question in this case is whether the pre-apprendi 848 crack offense of which Mr. Thomas was convicted could have resulted in a mandatory life sentence. The answer is yes, because for defendants like Mr. Thomas, violations of 848 constituted a single offense based on a single set of elements that exposed every defendant to a mandatory life sentence. Consequently, because the Fair Sentencing Act modified the quantity of crack required to trigger a mandatory life sentence, a pre-apprendi violation of 848 is a covered offense.
You have to deal with Terry, don't you?
Yes, Your Honor. Terry does not impact the argument about pre-apprendi cases. And again, it's because before apprendi, 848 A through C defined a single offense. And the Fair Sentencing Act modified the penalties for 848A, or I'm sorry, for 848 generally, by changing the quantity of drugs required for a mandatory life sentence. So at the outset, it's indisputable that the penalties for a violation of 848A involving crack were changed by the Fair Sentencing Act.
All that is correct, but in Terry, the sentence that's given us pause, or give me pause, is whether this Fair Sentencing Act modified the statutory penalties for petitioner's offense. And the offense here is a CCE, and looks to me the penalties are the same for that offense. What you are speaking to are the underlying supporting type offenses for which there might have been modification, but it didn't change the penalty for the offense that the petitioner faced here. That's the Terry problem I'm seeing here. That's the Terry thing, and that's what I'd like for you to address.
Mm-hmm. And I'm happy to. If you will bear with me, I have 5 points to make in connection with that argument. First, it is important to recognize that this is a pre-Apprendi case, and Terry said nothing about Apprendi. In fact, it was a post-Apprendi case where the defendant received the protections conferred by Apprendi. And the reason that it's a pre-Apprendi case is important is because the elements of drug offenses today, after Apprendi, are different from the elements of drug offenses before that decision. Before Apprendi, drug weight setting statutory sentencing ranges were considered sentencing factors to be determined by a court at sentencing using a preponderance standard. They were not considered elements that had to be charged and proven beyond a reasonable doubt or admitted by a defendant at his plea. The same was true in CCE cases before Apprendi. The government did not have to establish drug quantity at the guilt stage to increase a mandatory minimum because the maximum was life under both 848A and B. In other words, before Apprendi, using a Mathis-style type elements analysis, 848 defined only one statutory offense because drug weight at the time was a sentencing factor, not an element. What that means is that in pre-Apprendi cases, all defendants convicted of 848 faced a statutory sentencing range between 20 years and mandatory life, depending on what the government elected to prove at sentencing. Fourth, as a result, when Mr. Thomas pleaded guilty, he was convicted of a unitary offense that included mandatory life in the statutory sentencing range. And in fact, the government below was very clear, and this is at Joint Appendix page 100, that Mr. Thomas, quote, did qualify for a maximum mandatory life sentence under 848B, close quote. So fifth and finally, as I was starting to argue a few minutes ago, the Fair Sentencing Act modified the penalties for 848 as a whole by changing, for pre-Apprendi cases, by changing the amount of crack required to trigger a mandatory life sentence.
So what I'm interested in hearing the answer to, and I appreciate your pre-Apprendi reference here, but if the Fair Sentencing Act had been in place when he was sentenced, would it have altered the statutory penalty for his continuing criminal enterprise count at all? And keep in mind that it didn't modify 848A, which is what he was indicted for.
No, Judge Wynn. In fact, if you read the indictment carefully,
tell me no. What are you saying no to? In other words, if the Fair Sentencing Act had been in place, would he have altered the statutory penalty for his continuing criminal enterprise at all?
Yes, Your Honor, and that's because when you read Count 2 closely, Count 2 specifically incorporates by reference Count 1 and a number of other counts. Of particular note, it incorporates count 21, which alleged a quantity of 1.5 kilos of crack. Today, the Fair Sentencing Act, under the Fair Sentencing Act, the government would be required to prove 8.4 kilos of crack. That is not.
I accept that, and I agree with everything you just said, that today regarding those offenses that are incorporated, the question is the continuing criminal enterprise charge, not what it incorporated, but that in of itself. Would the Fair Sentencing Act have changed, altered the statutory penalty at all?
Again,
and
Your
understand
Honor.
Now, the penalties for count 2 do not depend on drug weights.
I disagree, Your Honor. And again, this is for
Disagreeing
pre-Apprendi
regarding,
cases.
tell me specifically what you're disagreeing with.
I disagree that the Fair Sentencing Act did not modify the penalties for the general CCE offense. It did modify the penalties because before Apprendi, Mr. Thomas was pleading guilty to a unitary offense that included the possibility of mandatory life in the discretion of the prosecutor at sentencing. And that's because weight was a sentencing factor. After Apprendi, we know that that drug weight had to have been charged. I'm sorry, I heard some noise.
We did too.
And I don't think it's in my head.
No, we heard it too.
So because the indictment, because count 2 incorporated by reference, and as essentially it says, as reprinted, as included herein, as in count 2, it alleged only 1.5 kilos of crack, which at that time was sufficient to trigger an 848B penalty in the discretion of the government if it chose to pursue it at sentencing. But after the Fair Sentencing Act, the indictment had to allege 8.4 kilos of crack in order for the government.
I don't want to go any further, but I want to make sure I'm clear. He was indicted for 848A, not B. And that seems to be a big differentiator. I understand hypothetically he could have been indicted for something different, and yeah, it may have made a difference. But that's not what he was indicted for. That's not what he's there. And so what I see, and maybe other side can explain if agree or not agree, but it seems like the penalties for count 2 do not depend on drug weights.
Your Honor, if you are referring to page 48 of the joint appendix, which is the tail end of the CCE charge in count 2, where it says all in violation of 848A and C, that statutory reference is not binding. The body of count 2 incorporates a quantity of 1.5 kilos.
Well, so that we agree, he was actually indicted for 848A, not B, not C. Is that correct or not?
No, I mean, he was indicted for 848C. The indictment happened to specify the A penalty provision, but that was not binding.
I see.
The court was free.
So A and C, he was indicted together for those 2.
Yes, and there have been cases, pre-Apprendi cases, where the government, in fact, indicted A, B, and C. And, you know, they were trying to cover the waterfront. Now, the government here didn't happen to do that, but that does not mean that a mandatory life, that the government was prohibited from, at sentencing, seeking a mandatory life sentence, as the government below stated.
You're going with this. You're saying he could have been indicted for B, and in many cases the government does, but here he was only indicted for A and C. But we should look at this as though he had been indicted for B, maybe E, and whatever else is there. Is that true? Is that where you're going with this?
That That's not exactly my argument. What the court needs to focus on is the body of the charge in the indictment, not the statutory references, which are not binding. There could be errors.
Not the specific crime for which he was indicted for. We look at the general, what he could have been indicted for. Is that what you're saying?
No, I'm saying that he was in fact indicted for an offense under subsection B, both because, and I'll read this.
You tell us what you're reading from?
Okay, yes, page 47, starting with Mr. Thomas's full name. Mr. Thomas did unlawfully, knowingly, and intentionally violate Title 21, USC Code Sections 841 and 846. Such violations including, but not limited to, those violations alleged in the instant indictment, specifically counts 1 and counts 3 through 21, which counts are realleged and incorporated by reference as though fully set forth in this count. Count 21 very clearly alleged a quantity of 1.5 kilos, and count 21, Your Honor, is on page 58. So that is, the government didn't literally reprint it in count 2, but it certainly made clear that count 21 was incorporated as though fully set forth in count 2, and count 21 alleged a PWID offense of 1.5 kilos of crack. Today, that quantity would not trigger subsection B. It would have to be 8.4 kilos of crack.
The disparity that Congress sought to address in the Fair Sentencing Act is baked into that count 21, as you said, because it's 1.5 kilograms is required. And now that would be a whole lot more to rectify the crack powder versus base cocaine difference. Is that right?
Yes, Judge Gregory, that is entirely correct. I see that my time is up. If the court has no further questions, I will reserve the remainder of my time for rebuttal.
Thank you, Ms. Pratt. Mr. Cook?
May it please the court. As I understand the defendant's argument at this juncture, there isn't an argument from the defense that an 848A and C offense is a covered offense after Terry. The statutory penalty range is 20 years to life for that offense, and the Fair Sentencing Act has not altered that penalty range in any respect. And
but you heard her explanation, and I want to make sure I heard it correctly too. But somehow 848B was incorporated in that argument.
Right.
And
so
you have just taken it out by saying A and C. I want you to make sure you are addressing her specific statements, and then do that in light of Chief Judge Gregory's question in terms of this all-encompassing aspect of it.
Sure. So this offense, the indictment alleges an A and C offense. And then we know at sentencing, B was not treated as a sentencing factor because the district court found that the drug quantity in this case was 76 kilograms that were attributable to this defendant. That's Joint Appendix page 194. If B had been treated as a sentencing factor built into count 2, the court would have imposed mandatory life, but the court did not. And that reflected everyone's correct understanding of the way the 848 works, which is this was a 848A and C offense. And so I don't think it is tenable in this case to say that this defendant was exposed to the B provision and that it was built into the offense, because he did not receive a mandatory life sentence, and the court made the findings that would have triggered that. And moreover, we know from what the Supreme Court said in Terry that you look at offenses separately. So in Terry, an 841B1A offense and a B1B offense for crack is a covered offense, but a C offense, 841 B1C offense is not. Similarly here, you distinguish the 848A and C offense from the mandatory life offense in 848B. And they are distinct offenses, and that distinct offense was not applied in this case.
Do you dispute what counsel said, Ms. Pratt said about count 21, having a drug amount involved?
It does allege a drug amount, but that doesn't make count 2 an 848B offense. And it wasn't treated as such in this case.
I mean, it doesn't make it an offense. It makes it a requirement. It's an element.
I don't think that's right, Your Honor.
Okay, well, why go to 21? Why is that 1.5 kilogram not an element that's to be proven?
Well, let me go. I think the
go where
easiest
I'm
way.
asking you to go right now. Tell me
Sure.
why that's not an element to be proven, and it's a drug amount.
I don't think that it counts as an element.
What you think? Tell what does it say? Is it stated as a requirement to be proven?
I mean, no, because for the simple reason that you can have facts in an indictment that don't require you to treat it as an element. And if you look at what the Supreme Court said in Terry about—
Why do you keep going to Terry? Terry, the Supreme Court, okay, the Supreme Court, obviously we have followed the Supreme Court, but right now we're following something that was pre-Terry right now. And that is, are you saying on count 21 that no drug amount had to be proven?
That's right, Your Honor. Now, and let me, again, in Terry, what the Supreme Court said is it was commonplace and it is an accepted practice that you could take, say, a 5 kilogram crack case and charge it as a B1C offense. The Supreme Court said specifically that that could be done and is done. And that is exactly analogous here, where you have not alleged in count 2 that this is an 848B offense. And again, we know that it is not an 848B offense because the facts as found establish that this could have been a mandatory life case, but it wasn't. If the defense counsel argued were right that this is governed by B, this defendant on the facts found at sentencing would have mandatory life, but he doesn't. The indictment didn't charge it and it wasn't applied. This simply isn't a case where 848B is treated as an offense element. We also know under governing law that 848B is indeed a distinct element. And that is the applicable law that governs 848. Now, there was a time where courts thought that that was not the case, but when courts construe statutes and the Constitution, they are saying what they mean for all time. And so that's a well-accepted principle of law. We saw it illustrated most recently in the Supreme Court's opinion in Palomar Santiago. It goes back to cases like Rivers versus Roadway Express. When the court says what the statute means, that's what it has always meant. And we know that a mandatory life sentence has to be, under 848B, a distinct element of the offense. And it wasn't charged here and it wasn't applied here. And as Terry has said—
I'm trying to cabin, I mean, we've really gone quite, I mean, it's all in line with it, but I want to understand what's going on here in light of Terry. And if I'm understanding correctly, there's a subsection here that you say he wasn't charged for, but it was modified. And it was modified by the Fair Sentencing Act. But it didn't modify the offense, the actual offense. So that even if it was an element to be proven, the penalties that we look to aren't the penalties for that element. They're the penalties for the offense under Terry. Is that where you're going with this?
I'm not sure. I may not be following Your Honor's question. Terry tells us to look at.
In other words, we're looking at the
Separate offenses.
subsections that supported this continuing criminal enterprise. And we know that a subsection of it was modified, but you are saying wasn't charged with that. And yet that subsection, the penalties for that would change. But when you look at the total offense, which is a continuing criminal enterprise, the penalty for the offense appears to be the same. But if I'm hearing your opposing counsel, there's an incorporation of B that she said could have been there that could have gotten a mandatory life sentence.
Right, and that argument is just unsustainable under Terry. The Supreme Court said in Terry that if you had a 5-gram crack case and you charged it under B1C, that would not be a covered offense. The Supreme Court settled that question. This is exactly analogous. So 848A and C function materially indistinguishably for purposes of the covered offense analysis from B1C. And the fact that you could have charged an 848A and C offense as an 848B offense is exactly the same as saying you could have charged an 841B1C offense as a higher drug quantity under 841B1B, and that would have been a covered offense, but you didn't charge it, so it's not a covered offense. I mean, I don't see how, under the logic of Terry, this argument the defendant is advancing could possibly work. I mean, Terry forecloses it.
The point, Mr. Cook, now talk about the underlying offense. Forget about the CCE, the one that made him qualified there. Didn't the Fair Sentencing Act modify the drug weights in that underlying conviction?
I'm not sure I understand your
conviction
question.
that he had a prior conviction, correct?
I mean, he didn't have an enhanced penalty here because of a prior drug offense.
Okay. So, but did it not, in the scheme of it, again, you read out of it, you read that totally out of the scheme of this sentencing, was it not, did the Fair Sentencing Act, if you say it doesn't have to be an actual conviction of an offense, but an actual conviction, didn't the drug weights modify, weren't they modified by the federal sentencing guideline?
I may not be following your Honor's question, but is your Honor's question, the indictment charged offenses against this defendant that were covered offenses?
Right.
I agree that's true.
And
he didn't plead guilty to them.
Right.
And the fact that they were charged and could have been used, the facts of them, to establish an 848A offense simply doesn't establish that his 848A offense is a covered offense. Because again, it's exactly like the scenario of charging someone with a B1C offense that is not a covered offense, when factually you could have charged a B1B offense that would have been a covered offense. Terry settles that doesn't get you to a covered offense.
Well, you know, when you look at this case, and there's something else the judge did here, and that is, even if he did get the First Step Act, it would be discretionary. And the judge pretty much said he's going to go ahead and exercise his discretion right now and let you know I'm not changing it. So
that's true.
How does that play here? Does it, I mean, what's the force of that in our decisions here?
I think you could affirm on that basis and just say, even if it is a covered offense, it wouldn't have made a difference in this instance. In the government's response brief, we did say, look, if that was something the district judge said in denying the reconsideration motion that the defendant filed. And it is not a highly developed point on which there was a lot of argument back and forth. I could see, out of fairness, having the court consider that in greater detail on remand. But the reality is that the Fair Sentencing Act would not have had a material effect in this case It doesn't change the statutory penalties. This defendant did not get mandatory life.
You know, I think about this case, and you have a judge who says that. You know, I suppose you could do it more artfully or more directly and says, okay, I'm inclined not to grant this act, but let's say I'm going to go ahead and do it, but in my discretion, now I'm going to go ahead and proceed as though I did do it, and then simply say, I'm going to do it. I'm going to just keep the sentence as it is, which essentially, I guess that's what he's saying. So you say that could be a grounds for affirmance, but it seems to be a ringer for an affirmance if you approach it from that perspective. I mean, it's not the situation. We of course have cases in which we have said that if a judge says, well, okay, like an enhancement error was made, that even though it was made, he would have entered the same sentence. And we've had cases that say, okay, that's enough. And I don't know how this is different, but it seems even stronger here because this is clearly within the discretion. To get First Step Act relief is a discretionary thing. There's even if you win it, you don't get relief unless the judge wants to give it to you. And he says, no, I'm not going to give it.
I agree. And I would add to that this defendant's sentence is not being determined by a statutory mandatory minimum. He didn't get the life sentence. He had a range 20 years to life. He continues to have a range of 20 to life. And the guidelines in this case have not changed under current law. Under current law, he continues to have exactly the same 360-month to life guideline range that he had when he was originally sentenced. Even under the Fair Sentencing Act, the drug quantities in this case, which are 76 kilograms, yield the very same guideline range. So it's quite understandable that a district judge would look at this and say, you know what, nothing is different. If you apply everything the same or apply all of current law, I would still impose the same sentence. That's a perfectly reasonable outcome in this case. But the fundamental point is there simply isn't a covered offense here because the statutory penalty range is exactly the same. It's 20 years to life. The Fair Sentencing Act had no bearing on the statutory penalty range for this offense. Unless the court has further questions, I'll ask that you affirm, but I'm happy to address any further points the panel has.
Have you come across cases with a similar fact where this argument has been made since Carey?
There might be some district court opinions, but I have not found the Court of Appeals.
Western District of Virginia. You haven't seen that district court opinion? You know it is.
I have a vague familiarity with that one, but it's not binding precedent. I think the basic framework from Terry is very clear here and forecloses treating this offense as a covered offense.
Did Terry vacate and remand a bunch of cases?
I think there were some that were, sent back to lower courts as a result of it. But the government's position was that before Terry, that a B1C offense is a covered offense. We were not bringing cert petitions on that point. So there weren't like a bunch of cases the government had lost that we were saying, please re-examine. And so I think that significantly—
So help me here. How did the court come to decide what it did?
In Terry?
Yeah.
The court appointed an amicus to argue the point that B1C is not a covered offense, and then the court agreed with the amicus.
And so the Solicitor General took the other side?
That's right. Actually, the Solicitor General's office took both views. Initially, the Solicitor General's office took the position that B1C is not a covered offense. That was the position when this court issued its opinion in Woodson, rejecting the government's view. At the time of the briefing in Terry, the government changed its position and said, no, B1C is a covered offense. At that point, the Supreme Court appointed an amicus, and then the Supreme Court agreed with the amicus and the government's former position.
No wonder I'm so confused.
It's confusing.
Thank you.
Well, since you got a minute, why don't you tell us a little bit about this Apprendi, pre-Apprendi argument that was made?
I don't think that the Apprendi line of cases makes a difference in how you analyze the covered offense inquiry. First of all, again, that's not what happened in this case. Nobody thought that 848B was a sentencing factor. If they did, this defendant would have gotten mandatory life. So if the defendant's argument is apply the incorrect offense elements and my guy wins, that wasn't what happened here. The correct elements were applied. My second point would be that as a matter of law, when courts construe statutes in the Constitution, they are saying what they always meant. And so in this case, it is always true that 848B is an element that creates a distinct offense. That's just follows from cases like the Rivers versus Broadway Express principle that the Supreme Court reaffirmed in Palomar Santiago, and cases like Danforth versus Minnesota about constitutional law. When the court construes the Constitution, it's what it always means. So there's that point. Another point that I would make is that the defendant's, Terry itself, when it spoke about the elements of 841, it said before 2010, when the Fair Sentencing Act, the elements were, and then it described the elements of 841A and B. And those elements built in what we know Apprendi law has done to our understanding of 841. The Supreme Court didn't say between Apprendi and 2010, here are the elements. It said, here's the elements that were in effect before 2010. So Terry itself undercuts the notion that you would create some kind of dividing line with Apprendi. And the last point I would make about it is this is a really bad way to approach the statute from a practical standpoint, because what it would send courts off to do is to try to figure out in a circuit's law when a shift in the interpretation of 848 occurred. And that's going to be very hard to discern, and it's going to produce a lot of arbitrary results where a defendant with an 848A and C offense in one circuit at one point in time is going to get relief, and in another circuit isn't. And on the government's interpretation, which is that the elements are what they are and they've always been, every defendant subject to an 848B mandatory life sentence will have an opportunity to come in and say, I was subject to that sentence. 848B creates a distinct crime, and it should be treated as a covered offense, and I should get relief. So I don't think the government's view produces any kind of unfairness that precludes anyone from getting relief who is actually subject to the mandatory life sentence. The defendant's view is just, I think, at war with the way we approach statutory interpretation. Is very difficult to apply, and in any case, doesn't reflect what happened in this case at all.
All right. Thank you, Mr. Cook. Ms. Pratt, you have some time reserved.
Thank you, Your Honor. With regard to Terry simply did not address the Apprendi issue. It had no need to, because Mr. Terry was prosecuted in 2008, well after Apprendi made clear that drug quantity was an element. What this case, in fact, is like is 924C, where up until Elaine, the government didn't have to prove any fact that increased the mandatory minimum. So, for example, a defendant would be advised at sentencing, at his plea, that he faced a range of 10 years to life, and then lo and behold, at sentencing, he gets a mandatory minimum of 7 or 10 years, depending on if the government proves a brandish or a discharge. Next, to prove even a basic C offense, which is the provision that in fact defines the CCE offense, to prove it as charged, the government, the government didn't have to incorporate references to any other counts. So it happened to, but that's not necessarily critical. And the point is, before Apprendi, any defendant convicted of 848A, of 848C was potentially subject to a B penalty, and whether to seek a mandatory sentence was a question of the government's discretion. And the government here, notwithstanding the judge's findings, chose not to, so far as we can tell, chose not to seek a mandatory sentence. Judge Wynn, in terms of your questions concerning an alternative ruling, when the what Judge Dumar was addressing was the guideline range and the fact that the guideline range didn't change. That is a 3553A factor for the court to consider when deciding the extent of any reduction after the eligibility determination. Because of the judge's finding of ineligibility, the district court simply never did a full 3553A analysis. Because he declined to appoint counsel, there was no mitigating evidence put on, nothing about, say, Mr. Thomas's record in prison, that kind of thing that is typically considered as part of the 3553A factors. So if we absolutely do request a remand on that basis. And furthermore, there is still harm because the term of imprisonment could still be reduced to time served, and the 5-year term of supervised release could be imposed or could also be reduced.
So you're saying it was an abuse of that discretion to review those guidelines and find nothing changed and then deny relief?
The fact that the guideline range didn't change is simply one consideration, and there are other considerations. And the judge didn't consider anything else. He didn't consider the nature of the offense, or more to the point, he didn't consider Mr. Thomas's history and characteristics. And I'm sorry, returning to the, let's see, I'm trying to read my notes here.
Well, on that point, I just think that's important because, I understand the First Step Act, if it is granted, it's basically entirely discretionary up to the judge whether to do it.
It is, but
which all the factors that you bring up, and of course this is the first time we're hearing it. I don't think you put that in your brief about the judge not doing all those things, but that's all well and good. I mean, but I'm concerned in terms of, well, what happens if you get first step relief and the judge says, my discretion, it's my discretion, I choose, I've looked at it and considered, and I'm just not going to do anything. And we've got a case pretty much on point that says the judge can pretty much do that.
That is correct, Judge Wynn.
And that's what he said he was doing. He said even if you got this relief on the first step, in my discretion, I would not give him relief.
I think the judge was basically saying that because the guideline range didn't change, he would not give relief. But that was without considering the other 3553A factors. Let me just go back to one final point concerning Terry and whether or not the guideline range changed. And I'd like to offer up this example. Let's say that there is a defendant who is charged under 841A1A with a 50-gram offense, crack offense. He has one prior conviction, so he's facing a mandatory minimum of 20 years to life. Under 841, and he gets 25 years. Under 841, after the Fair Sentencing Act, he would be looking at a range of 10 years to life under 841B1B based on one prior conviction. So the maximum, the range is effectively the same given that he got a 25-year sentence. But there's no question that that defendant would be found eligible. And the same holds true, the same analysis applies here. And for that reason, and so for that reason, we believe that the sentencing range for Mr. Thomas's 848 offense was not simply 20 years to life, rather it included mandatory life. That range was modified by the Fair Sentencing Act's changes to the triggering quantity of crack in 841B1B. As a result, his offense is a covered offense, and accordingly, this court should find Mr. Thomas eligible under 404A, reverse the district court's finding of ineligibility, and vacate and remand this case. Thank you.
All right. Thank you, Ms. Pratt, and thank you, Mr. Cook, for your arguments and your being here. We would love to come down and shake your hand, but we cannot. But please know that we appreciate your being here and your arguments, and we wish you well and be safe. Thank you so much. Now,
thank you, Your Honors.
Indeed. We'll now ask the deputy clerk to adjourn the court this afternoon.